on one side of this debate about whether Goldman should actually be charged, indicted, is securities attorney Andrew Stoltmann. He believes that Goldman Sachs and its senior executives absolutely should be indicted. On the other, John Singer, a partner at Singer Deutsch, who thinks the feds should stop making Goldman a convenient scapegoat. Also joining us in the discussion is CNBC's Kate Kelly. Welcome to you all. Mr. Singer, let me begin with you. You rest your case, I take it, that an indictment of Goldman Sachs would be terribly detrimental to the overall financial system. Why should that matter if there are reasonable charges that could be brought for serious wrongdoing?
Well, first of all, prosecutors have broad discretion in what kind of cases they want to commence, but there's no doubt that if Goldman, the entity, is indicted, it's akin to a death sentence for not only Goldman, but the impact on the markets as a whole would be so pernicious, and what you'd see is an eventuation.
But that wasn't Tyler's question. Tyler's question was, put that aside, are there legitimate reasons beyond that? If we could travel to utopia and assume that there wouldn't necessarily be all those horrendous consequences that you talk about, are there reasons to indict them?
Just because somebody's big, if they have committed some sort of criminal activity, doesn't mean that they should skate, right?
No, that's true. But if you take a look at Carl Levin's, the Senate Permanent Subcommittee on Investigations, their report, they were really focused much more on the perjurious or allegedly perjurious testimony promulgated by a lot of the senior executives. They weren't saying that the Goldman as a whole, the entity, had perpetrated securities fraud. They were much more concerned with some of the allegedly fallacious testimony given by various executives. So the answer to your question is we don't know right now if there's enough to indict Goldman, but you have to look at the macro impact on the market, given it's such a big player here.
Mr. Stoltmann, what do we know? And Mr. Singer's point is correct in that an awful lot of the allegations circled around whether there was perjurious testimony by Mr. Blankfein and others. None other than Andrew Ross Sorkin, who has been, pretty hard on Goldman from time to time, says that, on that particular point, whether Goldman was long or short or net long or net short, that may not be such an easy case to make.
I disagree. I mean, that is just one part of Senator Levin's report. If you look at it, he has made very clear allegations and really provided a crystal clear roadmap that the firm engaged in securities fraud with such deals like the Timberwolf CDO, the Abacus CDO deal. There's also charges or allegations related to traders intentionally driving down the prices of these securities so Goldman traders can buy them on the cheap. So the fact that Goldman may have some serious implications and may melt down if they're indicted, that shouldn't be a reason not to indict them. In fact, I make the argument that if you look at it, the prophylactic or the deterrent effect of indicting a firm like Goldman will be so strong in preventing future near global worldwide financial meltdowns.
Kate, react to John Singer's claim that perhaps there would be disastrous results in the financial markets if Goldman is indicted.
I disagree.
Well, let me just jump in for a second. I kind of want to speak to Michelle's point about let's travel to utopia for a second. I think before we decide whether or not this would have a pernicious effect, we have to think about the legitimacy about making a case. Now, I wrote a story for the Wall Street Journal in the fourth quarter of 2007 about the subprime short that made Goldman so much money. Now, of course, as we know, it was offset by a number of long positions that they had, and they were also selling them to clients. If you read the Abacus lawsuit, you'll see more details on an example of that. But frankly, I think that while Goldman was shrewd in what it ultimately did by shorting subprime, I don't get the sense from my reporting that it was an attempt to fleece investors and take advantage of people while making out like bandits on the other side. There was much debate inside the firm about what to do and when to do it. And in fact, the guys who had the short on were constantly arguing with risk management and senior executives about whether to take the trade off. In the end, they did well. But I think in the fixed income market, especially with liquid bonds like this, you're dealing with very complex markets, and you do have dealers that act as market makers and prop traders. Now, I'm not saying that's right, and that is something we'll talk about as it pertains to Dodd-Frank, I know, but it was a reality back then, and so you had kind of sometimes the right side not coordinating with the left.
Look, I don't have a problem with them shorting the market. Absolutely nothing is wrong with that. I think what Senator Levin argued in his 650-page report is that Goldman was lying to clients about the positions it was taking. It was lying about the underlying collateral with respect to some of these CDOs, and I think that's where you get into the securities fraud. Simply shorting the market, nothing's wrong with that, but you can't lie to clients. I think that's what Goldman did.
Well, gentlemen, thank you very much, and Kate, great to have you with us. Mr. Singer, Mr. Stoltmann, we'll have you back soon.